Hello, my name is Michael Tesoro, and I've prepared this ACCC case note entitled Slating Small Business. And that's a bit of a bad pun because the two companies involved in this case, ACCC and First Class Slate Roofing, were involved in the slate roof industry. But what I'm seeking to get at here is that the penalties which apply under the Competition and Consumer Act and the Australian consumer law at the moment are so high that they're having the impact of slating small businesses. And the implications are that if some new changes that have been proposed by the Albanese government come in, that the impact on small business is going to be made much worse. A bit of background about myself: I'm a competition and consumer lawyer, and I've been running my own practice at Tesoro Consulting for the last 14 years. Prior to that, I worked at the ACCC for 15 years in a variety of different roles, including as a director of enforcement. The outline of the presentation, I'll start with a couple of definitions, then look at the background to the case, then discuss the decision of Justice Yates, which is a very short decision, and there's not a lot of law in it, so that won't be a long discussion. Then look at the implications of the case, and then finish with some commentary. Now, the first definition is slating. As you are aware, the name of the presentation is Slating Small Business, and slating means to thrash or pummel severely. And so I guess the main argument here is the penalties are so large that they are having the effect of thrashing and pummeling severely small businesses who generally, if they get sued by the ACCC, can't afford to fight the case, and in most cases go into liquidation either at the very beginning of the litigation or somewhere along the way. And that situation is unacceptable. I don't think that's really what the civil penalty provision should be doing. And there's a strong likelihood that this situation of thrashing or pummeling small businesses severely is going to be exacerbated in the future if some proposed amendments come through to increase the base penalty from $10 million to $50 million. So I'll explore that issue in a bit more detail. The other issue is cartel provision, and that's a concept which is explained in section 45 AD of the Act, but unfortunately that's 1729 words long, so it's a very long, convoluted, complex provision, and it's really quite problematic that you have a definition of a key concept that is that difficult to follow. And you just got to wonder whether small businesses could be expected to understand this particular provision. What is cartel provision? Even big companies seem to have difficulty getting their head around this relevant legislation. What I've extracted there is the definition from the simplified outline in the legislation, which simply states a cartel provision is a provision which relates to price fixing, restriction of outputs, the allocation of customers, territories or suppliers, or bid rigging. And this particular case relates to bid rigging. Now, the ACCC commenced legal proceedings against two quite small roof tiling companies back in October 2021, and the conduct relates to two particular tenders where the parties cooperated. The four respondents were First Class Slate Roofing and the sole director of that company, and RAD Roofing Specialists and the sole director of that company. So four respondents. The first bit of conduct related to the Wesley College at Sydney Uni, and it involved First Class contacting two of their competitors, MLR and Mr. Shingles, which is the trading name of RAD Roofing, through text messages and phone calls, proposing that those two companies submit tender prices which were significantly higher than First Class's tender, so that First Class would win the particular tender. And the quid pro quo was that First Class would agree to pay both MLR and Mr. Shingles $10,000 in cash for submitting the higher tenders. One interesting aspect here is that the ACCC took proceedings against First Class and Mr. Shingles, but not against MLR. And I'm assuming that's because MLR might have blown the whistle on this particular cartel and received immunity and therefore weren't sued by the ACCC. I don't know that for a fact, but I'm assuming that's what happened in this particular case. And this particular agreement was put into effect in the sense that both MLR and Mr. Shingles did submit tenders for this particular job which were higher than First Class's tenders, and as a result First Class was successful in winning the tender. The next project related to a residential development in Bellevue Hill, and in this case the customer actually approached Mr. Shingles and First Class and asked for a tender, and the two companies communicated, this time by text message alone, and there was an agreement that Mr. Shingles would win this particular tender, so Mr. Shingles would supply the lower tender price and First Class would agree to submit a substantially higher tender price, and that would facilitate Mr. Shingles winning the tender. Now, one interesting aspect here was that the quid pro quo for First Class agreeing to put in this higher tender was that Mr. Shingles would pay $2,000. But because First Class already owed Mr. Shingles $10,000 for the Wesley College project, there was a decision to offset the $2,000 for this project against the $10,000 from the earlier project. So what happened here was, after the two tenders were let, both MLR and Mr. Shingles actually submitted invoices to First Class to receive the agreed payments. So I'm assuming MLR submitted an invoice for $10,000 to First Class and that Mr. Shingles submitted an invoice for $8,000. And it's fair to say this is unusual conduct for cartel participants to actually prepare an invoice in seeking to receive the agreed payment under a cartel agreement. Now, the decision of Justice Yates, he looked at the conduct and was quite satisfied that it was a deliberate bid rigging contravention of the legislation, and he noted that it was egregious conduct which seriously disrupted and corrupted the process of competition. He also noted that the customers were deprived the benefits of a competitive tender offer, so they paid more than they should have for their services. He also noted that the parties had engaged in the conduct deliberately and that their conduct involved elements of falsification and concealment. But he also noted that it was the first respondent, First Class, which had initiated the conduct in both cases. That's a significant issue in terms of penalty. Now, he also looked at the agreed penalty. He had to determine whether that was appropriate. On the negative side, obviously, the deliberateness of the conduct, the falsification, the concealment, these are all negative factors. But on the other hand, there were some mitigating factors. The first being that the benefits derived by the respondents from their illegal conduct was modest, so they didn't make a lot of money from their illegal conduct. Secondly, he noted that none of the respondents have ever been found to have breached the cartel provisions of the legislation, any other provisions of the Competition and Consumer Act, or indeed been involved in any other corporate misconduct. So both of these respondents had totally clean records, and that's a significant factor in their favour. Finally, he noted that the respondents had agreed to settling the case very early on, made full admissions, agreed statement of facts, joint submissions, agreed penalties. So all those factors combined to save both the regulator time and expense in running the case, as well as the court from having to have a contested trial. So that's a factor that can result in a significant reduction in the size of the penalty. Justice Yates also noted that there were some personal circumstances which he took into consideration in terms of the appropriateness of the penalty, and whilst the details of these personal circumstances weren't disclosed in the judgment, I'm assuming they related to financial circumstances of the business, potentially personal circumstances of the individual respondents, but this had some impact on the level of penalty. The other very significant consideration was that Justice Yates took into consideration the other remedies that had been agreed by the parties, and he looked at an entire suite of measures and placed weight on the cumulative effect of the entire suite of measures on achieving future compliance, on specific and general deterrence. So once he took in consideration the whole range of remedies, that meant that a lower penalty was appropriate in the circumstances, and he put particular weight on the public disclosure of the offending conduct to other participants in the industry. So I'll explain that a bit more in a moment, but that was a very significant factor in his penalty decision. Now, the penalties that were imposed were as follows: $280,000 against First Class, and you'll notice there that it's to be paid in instalments over 6 years, which is a very long period of time to pay civil pecuniary penalties. Also, Scott Barton was fined $60,000, which he could pay over 6 years, and that lengthy period reflects the ability of the company and the individual respondent to pay these penalties. Obviously, their financial circumstance was such they were not unable to pay it any quicker. Also, RAD was fined $65,000 and allowed to pay that over 18 months. And finally, Damien Hand was fined $15,000 and able to pay that over 18 months. Now, the other remedies that were ordered by the courts, firstly, declarations that the conduct was illegal, injunctions to prevent recurrence of the conduct, compliance orders requiring the individual directors to undertake some training, but most significantly, disclosure orders. And this was an educative notice which the parties had to prepare and at their own expense send to the Roofing Industry Association of New South Wales to be sent out to various members of that association. And it's an interesting document. It's quite lengthy, and what it seeks to do is to set out the conduct that the parties engaged in, the consequences of that conduct on themselves, and a plea, I think, to other members of the association that they not engage in similar conduct. And the way it's written is written in a non-legalistic manner. So I think people who are in the industry who don't have any legal training would be able to read this and understand that the likelihood of getting caught is high, that the implications of the conduct, not only financially but on their reputation and on their lives, is significant, and it is something that industry members have to be aware of and have to avoid at all costs. So I thought it's a very important remedy. It's not something you see very often in ACCC decisions, but I think it is an interesting remedy and will be quite significant in seeking to achieve general deterrence. So I can see the ACCC seeking these orders quite often in the future. Now, just looking at the implications of the case, if we look at the way the legislation is set out, it says that for making an agreement with the cartel provision, that the maximum penalty is $10 million. And there were two agreements. So the maximum penalty that each of the respondent companies would have been looking at is $20 million for having made the agreement. And there's a further penalty for giving effect to the agreement, again 2 times $10 million. So what you're looking at is both corporate respondents were looking at a maximum penalty of $40 million. As far as individual respondents go, the maximum penalty is $500,000. Again, 2 making agreement penalties, 2 giving effect agreement penalties. So both individual respondents were looking at a maximum personal penalty of $2 million. So then when you compare the maximum penalty with the penalty that was awarded, you see that the penalty that was awarded was very low in proportion to the maximum penalty. So in the first case, it was 0.7% of the maximum, in the second case 0.165 of the maximum, and as far as individual penalties go, 3% of the maximum for the first individual respondent and 0.75% for the second. So what you see here is you see penalties that are set out in the legislation, which the High Court said must be considered by the judge in Markarian, of $40 million, and then you see a final penalty imposed of $280,000. And you can't say that there was really any clear relationship between those two numbers. In actual fact, Yates in his decision doesn't even mention the maximum penalty, and I think that might be due to the fact that there's really no way to rationally and logically whittle down a penalty of $40 million to an agreed penalty of $280,000. So you've got this situation here where there's this disconnect between the maximum penalties and the penalties which are being awarded in cases against small businesses. The situation can get potentially worse under these proposed changes to the legislation set out by the Albanese government. And there's 2 major changes. The first is to increase the base penalty from $10 to $50 million, and secondly to increase the annual turnover penalty from 10% to 30%. Now, if this new regime was applied to the current case, the scenario would be significantly higher. So you would still have 2 making agreements, but it would be subject to maximum fines of $50 million each, and then you'd have 2 giving effect to the agreements, again 2 times $50 million. So the maximum penalty these small businesses would have been looking at would have been $200 million. by the same token, the individual personal penalties are going to be increasing from $500,000 to $2.5 million. So using the same approach, you would end up with a maximum personal penalty of $10 million. So once you compare the penalties imposed against the maximum penalties, you can see that the proportions go down considerably below what they were under the current legislation. So the corporate penalty for first class would be 0.14% of the maximum, and in the case of RAD roofing, it'd be 0.0325%. By the same token, the individual penalty would go down to 0.6 and 0.15% of the maximum penalties. So this just exacerbates the problems with the maximum penalties and the amounts that small businesses are able to pay. It'll be very difficult, I think, for a judge to try and whittle down a $200 million penalty down to $280,000. In actual fact, it would probably be impossible to do. And that means that many more small businesses who are taken to court by the ACCC are going to be unable to contest the proceedings, and they're going to end up going into liquidation. Now the thing is here, is this what the government is seeking to achieve, or is it trying to achieve something else? It seems quite apparent that government wants to impose bigger penalties on larger companies, but not necessarily impossibly large penalties on small business. The problem is that the way the legislation is set out at the moment and the way it's going to be drafted in the future is a very blunt instrument that hits both small and big businesses fairly equally, but obviously having a much more devastating effect on small business. So I think there is a way out of this, an alternative approach which the government should give serious consideration to. Now, it sounds somewhat counterintuitive, but rather than increase the $10 million base penalty to $50 million, what would make a lot more sense is to actually reduce it to $1 million. The government could still keep in the increased turnover threshold of 30% in the new legislation, but by reducing the base penalty to $1 million, you would end up with a much more graded penalty system that reflected the size and financial resources of small businesses who may be engaging in illegal conduct. So effectively, if a small business had a turnover of below 3.5 million, the maximum penalty would be the $1 million amount. However, as a small business's turnover increased over 3.5 million, the 30% of revenue figure would come into effect, and a small business with a turnover of $3.5 million would be subject to a maximum penalty of just over $1 million. And the level of penalty would increase incrementally as the small business's revenue increased. So as you can see there, a $5 million turnover would result in a $1.5 million maximum penalty. A $10 million corporation would result in a $3 million maximum penalty, and so on. So what you see here is you see a penalty regime which moves up incrementally in small steps, but still provides a sufficient sting to a small business who's engaged in illegal conduct, and the opportunities for the court to whittle down a penalty of $3 million to a lower penalty, or $1 million penalty down to $280,000 penalty, will be much more able to be done in a rational and principled way than is currently occurring. It seems that currently the judges are simply ignoring the maximum penalty in cases where they know it'll just create so many problems for them in seeking to justify an agreed penalty, or to impose a penalty that is in line with what the ACCC is seeking in the litigation. So the commentary about this proposed issue are as follows. Firstly, I think the pecuniary penalties under the Competition and Consumer Act and the Australian Consumer Law are simply too high. Having a base penalty of $10 million means that will apply to every small business, and often that will be much too high a penalty given the size of the business and the nature of the conduct. But the court is required by the legislation to start there. The second thing is that once a small business is taken to court by the ACCC and they're looking at a penalty that starts at $10 million and may go down somewhat, but clearly not down to a very low number, is that the business have no option but to go out of business. They just liquidate and go broke. And I don't think that's what the legislation is seeking to achieve. It's not seeking to drive small business out of business. Also, it's quite apparent that the situation on small business is going to get a lot worse going forward if the proposed changes are introduced. The base penalty rises to $50 million. We're going to see a lot more small businesses going out of business. There's simply no way that even if they're able to contest the case and get to a penalty hearing, that the penalty that would be imposed would be something they'd be able to pay. So you're going to see a lot more small businesses giving up or simply going into liquidation because they simply can't afford to fight the case or to pay the resulting penalty. I think another problem with this particular regime that's in place and being proposed is that it makes it very hard for judges to arrive at sensible penalties. They know they're supposed to work out the maximum penalty, but if they work out the maximum penalty, then they have the unenviable task of seeking to rationalise a much lower penalty that has some relationship to the maximum. And that can be almost impossible if you're starting with a penalty of, in this particular case, you're starting with a penalty of $40 million and you're seeking to justify an agreed penalty of $280,000. It's just too difficult to provide cogent, credible reasons for such a radical reduction in the penalty from the maximum. So I think if the penalties were set out in a more graded manner, the judges would find it much easier to start with a sensible maximum penalty and to apply the relevant factors to that maximum penalty and arrive at a number that makes sense, that is just in the circumstances, and which a small business has some capacity to pay. The final issue, I think, is the approach that courts have taken to setting civil pecuniary penalties, where they resolve from the idea that it needs to be some sort of mathematical exercise, preferring instead this idea of an instinctive synthesis. And it seems to me that maybe the acceptance of this instinctive synthesis approach should be abandoned, and we should start looking, and the legislature should start looking at a more scientific, mathematically based approach to setting civil pecuniary penalties, because individuals and corporations who are subject to penalties should have some idea of what the penalty is likely to be before they engage in conduct. Clearly, that's the whole idea of optimal civil pecuniary penalties, but at the moment really it's impossible to work out what penalty is going to be imposed in a particular case. So maybe it's time to replace the instinctive synthesis with a more principled set of guidelines or directions as to how to set penalties, and make the statutory maximum the starting point, and that factors be credited and be considered aggravating factors in relation to that maximum penalty, and then a final penalty arrived at, which is arrived at in a principled, predictable and credible way. So that's something that should be considered, because I think the instinctive synthesis is really not providing any clarity or guidance to business or individuals at the moment. So that's all I had. It's going to be interesting to see how the government responds to the comments it's received about the proposed changes to the civil pecuniary penalty regime, and whether it actually sees the benefits of taking a different approach that allows for a graded increase in penalties that won't result in small businesses being driven out of business. So it's not clear at the moment whether they're going to be seriously considering changes such as the one outlined in this particular presentation, but it'd be worthwhile for them to I guess take a more nuanced view as to the impact of these penalties on small business. So if you have any questions about this particular presentation, feel free to give me a call or send me an email. Bye-bye.